Welcome to our Shorthand Lab Prayagraj. Legal dictation. 5 seconds remaining. Start. The State Electricity Board is a state within the meaning of Article 12 of the Constitution of India, and it is a statutory authority stopper. If the board has the power to frame or revise the tariff as contained in Section 49 and other provisions of the 1948 Act, which is plenary in nature, unless a statutory provision is brought into force interdicting exercise of such power, it cannot be held to become denuded thereof a stopper. The power to make tariff would bring within its folds the power to revise the same stopper. Exercise of such powers from time to time would depend upon the exigencies thereof a stopper. The powers oblique guidelines under the provisions of 1998 Act were to be exercised by the Central Commission or the State Commission stopper. It must come into existence for the said purpose stopper. A non-obstinate clause contained in Section 29 or Section 52 of the 1998 Act would be attracted only when the Commission comes into force and not prior thereto stopper. The provisions of the said Act are to be exercised by the Commission for the purposes of the Act stopper. It must therefore come into existence before it can exercise its power stop para. It is therefore difficult for us to persuade ourselves that the factors enumerated in clauses (c) to (g) contained in subsection 2 of Section 29 of 1998 Act, providing for the principles required to be followed by the Commission, were binding on the state electricity boards also stopper. The state electricity boards are entitled to frame tariff in terms of the provisions contained in the 1948 Act stopper. The tariff so framed is legislative in character stopper. The board, as a statutory authority, is bound to exercise its jurisdiction within the four corners of the statute stopper. It must act in all fields, including the field of framing tariff, by adopting the provisions laid down in 1948 Act or the rules and regulations framed thereunder stopper. It is one thing to say that while framing tariff, it can only take into consideration the provisions laid down in the schedule appended the Act and obligor the directions contained in the policy decisions issued by the state, as also other statutory principles governing the same, but then a tariff framed by it cannot be held to be ultra vires only because it did not take into consideration certain principles laid down in clauses (c) to (g) of Section 2 of Section 29 of the 1998 Act stopper. It is for some significance to note that the Commission, in terms of clauses (a) and (b) of Section 2 of Section 29 of the 1998 Act, are required to follow the principles provided for under Sections 46, 56 and 57 of the 1998 Act, as also the 6th schedule appended thereto stopper. The 1998 Act therefore recognizes the principles contained in the 1948 Act also stopper. It would be absurd to suggest that the principles required to be adopted by the Commission were perforce required to be adopted by the electricity boards, despite the fact that the Commission did not come into existence stop para. The Commission has been empowered to frame tariff. It is, however, not been empowered to frame tariff with retrospective effect so as to cover a period before its constitution stopper. The matter might have been different if such a power has been conferred on the Commission stopper. It is now a well-settled principle of law that the rule of law inter alia postulates that all laws would be prospective subject of course to enactment and express provision to the contrary. Stop. On the aforementioned factual backdrop, we may notice that in the case of BSES bracket supra, the Electricity Commission was constituted on 5th August 1999. Stop. A dispute arose in regard to payment of standby charges by and between the licensee bracket Tata Power and the appellant therein BSES for the period 1st December 1998 to 31st March 1999. Stop. Thank you so much.